think we'll get started right away. So let me introduce our panelists for today. So Rosie Ortiz is an attorney at the Legal Aid Society of Metropolitan Family Services. And Henry Goetsch is at the Shriver Center. And today they're going to talk about the pending public charge changes. So thank you for being here. And I'll turn it over to you guys.
Thank you, Miguel, and thank you for having me. Again, my name is Andrea Kovach, and I work at the Sergeant Shriver National Center on Poverty Law. I work on our healthcare justice team. So I'm going to dive right in. We actually have a lot of content to cover in a short amount of time. The presentation today is going to cover where the public charge doctrine has sat for the last over 100 years. So we're going to do a really quick historical analysis of this public charge doctrine, what the public charge test has been for numerous years. Then we're going to go into the expected changes to the public charge test based on a leaked draft that was leaked in March of this year. After that, we're going to do a quick recap of the federal rulemaking process, because this is all coming about through the rulemaking authority that the president has. Then we're going to talk very briefly about the potential impact that we foresee in Illinois due to the expected changes to the public charge test. And I'm going to introduce a new coalition that was formed specifically to resist these changes called Protecting Immigrant Families Illinois, or PIF Illinois. So the first time that the public charge doctrine was mentioned in federal immigration law was back in 1882. And in that law, it essentially allows federal immigration officials to deny admission to the United States or deny adjustment to legal permanent resident status, otherwise known as green card, getting a green card, if the federal immigration official deems a person likely to become a public charge. And a public charge is defined as a person who is primarily dependent on the government for subsistence. Okay, so this was back in 1882. Now fast forward over 100 years to 1996. And there, as you all might recall, we have the Personal Responsibility and Work Opportunity Reconciliation Act, the Welfare Reform Law, and we have the Illegal Immigration Reform and Immigrant Responsibility Act. Between the 1882 and 1996, there really weren't a lot of changes to the public charge doctrine that are worth noting. Once those two acts were passed in 1996, there came some confusion about how immigrant eligibility for certain public benefits gets mixed in with the public charge assessment. And so based on that confusion about public charge assessments, in 1999, the U.S. Immigration and Naturalization Service, INS, they decided to issue proposed rules to provide what that assessment to determine someone in public charge should look like, because of all that confusion about so which immigrants are eligible for which public benefits and how does that fit in. So INS said in 1999, we'll issue proposed rules and we're going to issue field guidance that's going to clear this up as to how federal immigration officials should do this assessment as to whether someone's a public charge. Okay, so they issued proposed rules. They never issued final rules. Final rules were never promulgated. This is how the Trump administration, this is their opening to come in, and they're saying now that they will issue proposed and then final rules. The field guidance from 1999 has been used ever since. It's in effect today, September 13, 2018. because there have been no proposed rules filed as of today, September 13th, 2018. So that field guidance is in effect today. So what does that field guidance say? So it gives us a more of a roadmap for this assessment of public charge. So, and this is right from the field guidance. I've taken these bullets. So public charge means an alien who has become or is likely to become primarily dependent on the government for subsistence. There are two public benefits that federal immigration officials are allowed to look at in making the determination as to whether or not someone's a public charge. Two, the receipt of public cash assistance, so SSI, General Assistance, TANF, for income maintenance, or institutionalization for long-term care at government expense, which essentially is being in a nursing home being paid for by Medicaid. Now, these factors are part of the totality of the circumstances of the immigrant's life. So the immigration official doesn't stop there. They're required to look at the totality of the immigrant's life, including their age, their health, their family status, assets, resources, education, and skills. And if they find that, given the totality of the circumstances, that the applicant for the green card sitting before them is indeed a public charge, then they can be denied their green card, and that denial has to reflect consideration of each of these factors, and specifically articulate the reasons for the officer's determination. So this happens rarely, I'm told by immigration attorneys, and I'm told that the sponsor's affidavit of support is generally given very heavy weight, and if there is evidence that the applicant for the green card, for example, is on one of these public benefits or receives general assistance and it's possibly the sole income, that generally a very strong sponsor's affidavit of support is given such heavy weight that it usually overcomes that. So the test has been very narrow, and that is the test that has been, according to the 1999 field guidance, the test since then and is the test today. So who is subject to the test? This is one of the most important slides in the whole presentation because it's not every immigrant. And this is encoded in statute. So in order for the Trump administration to try to change this, they would have to go through Congress. They cannot change this in their rulemaking authority with the proposed rule. So people who live abroad and are seeking to enter or immigrate to the United States, so people who are applying for a visa to come to the United States, they would have their interview at a consulate office, for example. They would be subject to the public charge test. So they are abroad seeking to come into the United States. And just really briefly, a really quick digression, I have here FAM changes. FAM stands for the Foreign Affairs Manual. It's the manual that's used by U.S. State Department officials that they read, and there's an assessment in there that they use to assess whether someone who is seeking to come into the United States from abroad is a public charge, can be deemed a public charge. The Trump administration, via the U.S. State Department, has already made changes in the FAM, in the Foreign Affairs Manual, to broaden the public charge test. And we, meaning the broader legal aid and across the nation, are still trying to understand the impact of those changes that are happening in consular offices abroad. So that's already happened. The second group of people who are subject to the public charge test are people who are residing in the United States for the most part, and they're seeking to become a legal permanent resident, or in other words, obtain a green card. And these primarily are people who have come to the United States through a legal checkpoint, and they have a legal pathway to getting a green card. And we'll talk more about that, and Rosie will as well. Okay, this is one of the other most important slides, are the immigrants who are not subject to the public charge test. And this is also encoded in statute, so the Trump administration would need to go through Congress to make changes to this. I'm not going to read the entire list, you have it in front of you, but I do want to point out a couple of the bullets. So refugees and asylees are not subject to the public charge test. If someone is a legal permanent resident and they're wanting to apply to become a naturalized citizen, they are not subject to the public charge test. U visa, T visa status is not subject to the public charge test. So just to hit it home, we did put an example in here of someone who's an approved VAWA self-petitioner. She's eligible for a number of public benefits with that status, but she's worried that the receipt of those benefits could impact her ability to get a green card later. So she calls you up and she talks to you about this. If she adjusts as a VAWA self-petitioner to getting that green card, she is exempt from the public charge grounds. So that's how it works in practice. And then again, this slide just says that if you are deemed to be a public charge by the immigration official, you would not be admitted to the United States if you're seeking to come from abroad, or you would not be allowed to get the legal permanent residency status. So you would end up with the status that you already have coming into the application process. Okay. I'm going to turn it over to Rosie, who's going to talk about expected changes to the public charge test.
Thank you. Good afternoon, everyone. My name is Joseph Luzagasta, and like Ingrid said, I'm a staff attorney at Legal Aid Society. So my portion of this is to inform you of what we expect the changes will be based on the leaked memo. So as of right now, just to reiterate, like Andrea said, the 1999 guidance is still in play, but this is what they'd like to propose going forward. Okay. So the expected changes are these. In January of 2017, a draft executive order was leaked that included language that the Trump administration is saying that they'd like to change the public charge standards. Then in December of 2017, DHS announced that they wanted to change, that they were planning rulemaking to revise the standards, which they ended up doing January of 2018. And like Andrea mentioned, changes to the FAM, whereas basically they're starting to make those changes when Department of State is processing visas for people that like to come into the country. They've already started to make some of those changes. So what this slide highlights is the distinction of what is current law, which is literally the first two bullet points that are in black, and the red is what was leaked, that this is what they propose they want to change. So as you can see, the expansion list of the benefits that they are now considering is much larger than it was. And so originally it just, like Andrea mentioned, it was just those two tests, and now this is not an exhaustive list. This is clearly like what everything is leaked, and so when it finally does drop, then we'll really know whether or not these are in play. But at least for now, this is a pretty scary list because we know a lot of our clients are tapping into a lot of these services. If not for themselves, their family members. This is a list of some of the benefits that they've purposely said that they plan to exclude. But again, it's based on the leak. And so one of the reasons why they want to exclude them is because these benefits listed on this and the next slide primarily are given to an alien because of their past or current employment or contribution into the benefit system rather than the alien being able to support him or herself. And this is another slide of additional benefits that they're proposing to be excluded. You can see education is a very big concern for people. And so even though school is considered a public benefit, public schools are obtaining their funding in a very different way, and states are required for children to be in school regardless of their immigration status, which is why they added that to one of those lists. And then tax benefits as well. Like Andrea mentioned, I think out of all of the information we have for you, there's some very profound slides. This is probably one of the other most important ones. And so aside from expanding the list of types of benefits that they're concerned with now and wanting to use as a test, the additional proposed change is that not only that the individual seeking the immigration benefit is getting that benefit themselves, but rather also dependents, which include U.S. citizen children. And so as we know, a lot of U.S. citizen children are getting SNAP benefits or TANF or, like medical assistance, especially here in Illinois. And so they're proposing that if parents have U.S. citizen children that are tapping into these benefits, that is going to be included in this test. And so it literally turns it into, if I ever want to gain status, if I don't fall under any of those exempted groups, do I either want my child to have benefits or do I want a path to legal status in this country? And so I think out of everything that's kind of going on, this is probably the most profound and shocking. And that will have an impact on a lot of individuals because that literally does turn it into that, is do I ever want to gain status or do I want my child to have benefits? So like Andrea mentioned, while reviewing all of the benefits that people are tapping into, the test is a totality of the circumstances. So this is one of two slides that goes into some of the things that they're going to consider. So age, medical condition, family status, assets, financial status. One of the interesting things about financial status is that they want to consider credit reports. So not everyone has a credit report, right? If you don't have a social security number, you can't get credit. But other countries do have those systems in place, and the downfall of that is that having a credit report gives a lot of information, right? Like not only a score, but your payment history, how you are as a consumer, and so all of that is really troubling that they want to start reviewing all of that information. And education and skills, like their education level, if their work history, and things like that. So part of the totality test is an affidavit of support, which is basically a document that if someone is petitioning for someone else, that person is saying, I want this individual to come into the country, however, I am telling you, the government, that they are not going to become a public charge, that I will be in charge of them economically in case something happens. And so that is a part of some of the applications that are submitted. And they're saying if you fail to include that information, which is generally required, they'll start denying the application based on a public charge issue. So that's pretty a profound point. The leave charge also included heavily weighed positive and negative factors. And so it wasn't that big of a change, but I think the list and the way that they're doing it did differ to some extent. And so this is a list of some of the things that they are now considering. So in the March draft leak, they were saying it's going to be based on totality of the circumstances, but certain factors, they're going to look much more heavily in the negative and in the positive. And so the mere issue of having a heavily weight factor is not enough from them to make a public charge determination, but it's definitely going to impact their decision. So this is a list of some of the positive factors that they're willing to consider. But if you look at it, it's literally basically saying that they're willing to bring people into the country if they have at least 250, or if they're at the 250 federally poverty line, which is basically double of what the requirement is for the 96 law. And so we can see in the next slide that for 2018, a family of 1, 2, 3, or 4, this is the income that they would need to have to meet that 250 requirement, which is pretty large for some of our clients. So the DHS is considering not only if the individual is on these benefits, but also their dependents, including their U.S. citizen children. They're specifically saying that the benefits are not going to be counted until 60 days after the publication of the rule. So while that's a good point to say, because a lot of clients have heard that this information is out and are definitely in fear factor. And so we're trying to mitigate expectations that we know right now, currently you and or your family members are on benefits. However, you don't have to leave them as of now because one, all of this is leaked. right? We don't know if this is really what is going to be proposed at the end of the day. But they're even saying their leak memorandum that they're not going to factor it in until later. So they still have some time. But still, I'm trying to calm people down and trying to determine all of that is really difficult. Okay. And so aside from tapping into the 60 days, they're also going to do a 36-month look-back period. So from the day that the rule is finally in effect, they'll look 36 months back, but from that date. So, we used to have a date, right?
So, I can
Go
clarify.
ahead.
So the 36-month look-back period is a little tricky, but it wouldn't be until essentially 3 years and 2 months after the final date of the rule that there would be a full 36-month look-back period. So first, on the previous slide, we have the 60-day period that Rosie talked about, which in the weak draft it literally says, this gives immigrants a chance to disenroll in public benefits during the 60-day period. And then, fast forward 3 more years, and that would give the immigration official a full 36-month look-back period. So just to keep going on this example, so 6 months after the final date of the effective date of the rule, there would be first the 2 months grace period, and then there'd be 4 months. Let's say if somebody's sitting in an immigration official's office at the 6-month mark after the final date of the rule, the immigration official could look back those four months for all the new public benefits on the new list.
So if a green card application can be approved while someone is out of country or in the country, and so one of the things will happen is if the application is denied, and if it is denied for the reasoning behind it is because the individual is a public charge, they can be put into removal proceedings. Okay, so this is a nice little comparison list of what the test is now and what they're proposing. As you can see, it's pretty scary. Okay, so what can we do now? This has been out for some months, right? Like our coalition has been together for a couple months, and so the news is, articles have been done all over. I think people are also doing news stories on them, and so speaking to clients to see if they're exempt, trying to calm them down is that this is a leaked memo, it is not final, we don't know what will happen, however we anticipate that it is going to be a dramatic change, and just letting them know, like, right, there's no need for you to withdraw from benefits at this time, even though the rule said 60 days afterwards, and so there's still some time to work things out. Okay, so now we're moving on to the other important part of why we're here, and it's rulemaking. And so this is a slide basically of what the steps in rulemaking are, and so as you can see, the State Department updated their Federal Affairs Manual. USCIS is leaking their proposed rule, and right now the rule is with the Office of Management and Budget, and it's been there for some time, which is good for us because it's giving us more time to organize and kind of educate everyone. But eventually, what our goal is to submit comments, and so we can move. So what we'll do is, normally speaking, comments can be probably between 30 and 60 days. We're hoping for 60 because that'll give us more time to submit comments, and then they will review them, and then they'll finally make a decision on whether or not they're going to publish the rule as it is. So what we can do is, we as a coalition, there's a local one in Illinois, but there's also a national coalition. We've been working on drafting comments, and so that way, depending on, this does not only affect the legal community, it affects the health sector, it pretty much affects everything. And so we want to make sure that we do comments that are specific to our area, but also to others. And so we want people to submit comments, either as an individual, as an organization if possible. We're also looking for stories. If you have clients that are willing to come forward to submit how this is going to profoundly impact them. And then we are going to have microsites, and so that way you could either submit it through that site or you can do it through regulations.org, or .gov, I'm sorry, to submit comments, so that way everyone kind of gets a chance to kind of say report. And then PIF National, again, is run by CLASP and the National Immigrant Law Center, and they're also working on templates as well. So I think like among that organization and ours, we're trying to get all the comments together so that when it addresses all of the areas. And there's definitely value into adding comments. I think it's difficult to say whether or not it's really going to have an impact. But one of the reasons why we're pushing for it is because, like the slide says, all the comments can be used for evidence for APA challenges. It can support to repeal the rule in 2021. It'll bring national attention to the issue. We understand that not everyone, organizational-wise, is going to be able to submit comments, but even as you as an individual, I think the more comments that we can have, the better argument that we have. It doesn't necessarily always have to be a weak legal argument either, right? Like we need to come at it from multiple sides showing why this is not good and not, while legal arguments are going to be great, especially from us lawyers, but I think we need other ways of proving to them why this is not a good decision.
So I have a few slides on the potential impact of the expected changes to the public charge test. The first is a national lens, and the Migration Policy Institute did an analysis that found that more than 10 million non-citizens reside in benefits-receiving families. And they were using American Community Survey data that was just looking at 4 of the benefits, so this is actually an undercount. And when they did an analysis of how many non-citizens are using those 2 public benefits under the current policy that are in the current public charge draft, or current public charge test rather, and then they compared it to how many non-citizens they expect to be kind of caught in this now huge widening net under the terms of the draft rule, they found that there would be at least a 15-fold increase from 3% of non-citizens currently using those 2 public benefits to 47%. And again, this was just looking at those four of the public benefits. So again, it's an undercount, because when you go back and in the slide there that you have in front of you and you look at the expanded public charge test, it includes much more than these 4 benefits. It included Obamacare subsidies and housing assistance and TANF, SNAP, etc. So this is actually an undercount. And I don't have to tell this crowd that this will have such a chilling effect, not just on the immigrants who are actually going to be subject to the test, those applying for the green card who aren't exempt, but for the entire immigrant population in our country who may not know that they're exempt, or they might have family members who are applying to get the green card, etc. So just again, staying at kind of a high level, we expect that when the expected changes to the public charge test go through, that there's going to be a huge impact on all of the sectors, nutrition, housing, etc. This was just a snapshot of health. So if you think about it, if we have large swaths of immigrants who are eligible and enrolled in health coverage, we're going to see anywhere from 10 to 30% of them possibly disenrolling, which will lead providers to seeing sicker patients overall, delayed disease detection, increased number of patients that have unmanaged chronic conditions. We can even imagine potential tension among providers and patients. So if you think about, I'm sure your mind can go to many, many different scenarios. One example that I've given before is, think about a mom who's in the hospital giving birth to her baby, and it's apparent immediately that this baby needs to go to the NICU. The hospital's thinking to itself, okay, we're going to put the baby in the NICU. The mom's just gave birth in the United States. The baby's a U.S. citizen. In Illinois, it doesn't matter, but this baby would be enrolled in Medicaid. The mom who might be thinking about immigration consequences for that decision might say, no, wait, don't enroll my child in the Medicaid program, even if the baby qualifies. And it goes back to this choice that Rosie talked about. This proposed rule, this final rule, will not change immigrant eligibility for benefits. What it will do is cause certain immigrants to have to make this horrible choice, which may lead to tension among providers and patients. Increased uncompensated care costs from disenrolling in Medicaid, increased reliance on private community referrals, and then you can also see, I'm kind of going a little bit faster now, that all of the agencies that touch all of these sectors, so Department of Human Services, HFS, et cetera, they're going to need to retrain staff, change all of their consumer-facing documents, websites, et cetera, because of the expected changes in the charge. So this is just a snapshot. How are we doing on time? Sorry. Okay. I want to leave time for questions. So economic impact, this kind of touches a little bit more on the nutrition because SNAP and WIC are included in the expanded public charge test. How you can see that that will also have an economic impact. The certain tax credits were also included. I just want to highlight that. So people are going, it's not supposed to say foraging filing for refundable tax credits, but foregoing filing for refundable tax credits will also obviously have a negative economic impact. All right, I'm going to skip over to Illinois specific data. So we know that out of over 12 million in our state population, 1.76 million of those are immigrants. We're the 5th largest home to immigrants in the country. And the Migration Policy Institute has been combing through data that they have. I'm going to go to here are the 4 benefits that they looked at in the American Community Survey. So this is just Illinois, individuals and families receiving TANF who are non-citizens. Then I went ahead and put naturalized citizens and U.S. born for these 4 benefits as well, because again, it's going to have a chilling effect. And because U.S. born citizen kids, if they're in a family where they're a dependent and mom or dad is applying for their green card and they're not exempt, they can be captured in this as well. The Migration Policy Institute also did a projection for how many are eligible for the ACA subsidies, because the ACA subsidies, Obamacare subsidies, are also on the list under the expanded test. 1 in 4 children in Illinois have an immigrant parent, so we expect that because of, again, the expanded test, that there could be an increased public health risk from foregoing vaccinations and immunizations, just increased poverty overall, financial instability, and then, obviously, again, I don't have to tell you all that when you forego food assistance, nutrition assistance from SNAP and WIC, Medicaid assistance, what that could lead to. Illinois citizen kids. So this slide just shows Illinois citizen children that have a non-citizen parent, and it's over 440,000. And here I've listed how many have the all kids coverage here in Illinois, and then I called out how many are in families with less than 250% of the federal poverty level, because as Rosie mentioned, that is the poverty level that the Trump administration is saying you're in or out. So that's their baseline for just deciding whether you're worthy to get your green card. And then I'll go really quickly through this so that we have time to answer questions. Do you have a clarifying question?
Yeah, it was super fast.
Yeah,
Is that
yeah.
also what you meant in the previous slide by an immigrant parent, anyone with something other than full citizenship? The slide prior to this said 1 in 4 kids has an immigrant parent.
Right. So what's the question?
What does immigrant mean in that context? Does it mean the same as in the next slide where it's not?
No, hang on, let me get to that. They are different.
It's not that important. I'm just curious.
So when we go to a naturalized citizen, foreign born. And then actually, I think it is the same. That's, yeah.
Thanks.
No problem. So now we're going to go into, I'm sorry I'm going so fast. I didn't realize how little time we have left, and I want to make sure we have time for questions. So we've already alluded to the fact that there is a new coalition that was formed, Protecting Immigrant Families Illinois. It was convened by the Illinois Coalition for Immigrant and Refugee Rights, Legal Counsel on Health Justice, Latino Policy Forum, and the Shriver Center. We now have, I think, over 16 steering committee members representing diverse sectors that will be impacted by the expected changes to the public charge test. We have over 157 unique organizations that are that have signed up for our listserv, and we have over 259 folks signed up for our listserv. So if you are not signed up for our listserv and you would like to receive updates on the expected changes to the public charge test, we already have fact sheets. We've had a webinar. We will have another webinar once the proposed rule is filed. Please email us at pifillinois@povertylaw.org. The coalition really sees this as a long-term fight or resistance. We're just at the beginning of it right now, where we're trying to educate as many organizations as possible that serve immigrant communities about the expected changes to the public charge test. Once the proposed rule is actually filed, our second goal is to drive as many unique and numerous comment submissions as possible in the Federal Register, like Rosie had said. And then really, once the comment period window closes, our work is not done. When that final rule comes out, we're really going to have to gear up on making sure that our immigrant community across our state understands what this public charge test means for them. So when the final rule is published, we're really going to need everyone in this room to help us make that a reality, to provide accurate education and referrals. So please consider signing up for our coalition. And I think, let's see. Okay, good. We have 15 minutes for questions. So please feel free to ask anything. Yes.
This is like a stupid question in this room, but, and I'm sitting next to my immigration attorney, but I am not one.
Yeah.
I'm a general attorney. What are the entitlements that an individual has that does not have legal status in the United States? I understand all the implications for someone who has children that are American citizens and all the implications that I fully understand and understood. But I'm not clear what kind of benefits, medical, food, like you don't get SNAP if you don't have status, right?
So are you talking about an individual who is undocumented?
Yes.
Okay, so very briefly, so in Illinois, we have all kids for undocumented individuals, so that's up to 300%, or 300% of the poverty level under age 18. So there is health Medicaid, called the All Kids program for undocumented kids, up to 300% of the poverty level, up to age 18. And then Moms and Babies is also another Medicaid program here in Illinois. So you have to be an Illinois resident. It's open to pregnant women, regardless of immigration status, up to 200% of the federal poverty level. There are a lot of households, mixed status households, that have undocumented individuals where the household's receiving a benefit, a public benefit, based on the legal immigration status of someone else in the household. Do you want to add anything?
Sure. So the distinction is, as far as immigration is concerned, there's family-based immigration, there's employment-based immigration. If you don't fall on either of those, you kind of go to that big exemption list. Like, there's other ways of gaining status. So if you're the victim of a crime, you can possibly get a U. If you're a victim of trafficking, you can get a T. So for most individuals, the distinction is now adding and factoring in U.S. citizen dependents getting benefits. Because before, if a person is undocumented, but they have U.S. citizen children, there's no negative factors in being able to provide your child medical or food assistance. Now there is, because at some point, if they get married to someone who can eventually petition for them, or if there's another way of them being able to adjust, that's where it kicks in. So Andrea and I had spoken recently, like, what about DACA recipients, right? Like, these are young individuals that came into the country, and now some of them are able to gain status. So if that DACA recipient has U.S. citizen children, and that individual eventually marries and wants to become a green card holder, now that is a problem that they've been providing their child with benefits, right? And so unless they're on that exemption list, then people don't really have to worry about anything by statute, because they actually, usually because of their status, they actually have access to additional benefits, right? But that's kind of where it ties in.
And so, and Rosie's talking about in the world where this proposed rule has actually gone into effect. Yeah. Does that answer your
Yeah.
question? Okay. Yes.
Don't all immigrants have access to emergency Medicaid coverage as well?
Yes, so on the slide that talks about how the public charge test is going to be greatly expanded, and it says Medicaid, I hope on one of the next two slides it says emergency Medicaid was specifically excluded.
Okay.
Emergency Medicaid is very, very narrow. It's literally life or limb, so it's not full benefit comprehensive coverage the way that all kids, normal babies, ACA adult, family care are. But emergency Medicaid is specifically excluded in the leak draft. Yes.
Are they going to look at whether the person, let's say they're applying to come into the country, whether that person received the equivalent of public benefits in their home country? I'm glad to close the door with this.
All I can say to that question is that I don't remember anything in the leak draft referring back to that. I don't think so, but,
I
you
mean,
know,
if
stay
you're coming from
tuned.
some socialist country, like, you know, almost all of Europe, education is free. Is that a public benefit? If you're coming from if you've been in a
Right.
refugee camp and you got some kind of aid, are they going to say? I mean, I'm just suspicious for some reason.
So what I
How this
think,
is going to be applied by consular officers.
There would be definite, administrative challenges to trying to actually implement that if that's the case. But what were you going to say? Sorry.
so I think it didn't like blatantly say that, but I think under the totality of the circumstances, a person's age, their work history, I think like the whole mention about a credit score, while we do it in the U.S., other countries do it as well. And so that, while it doesn't blatantly say it, it kind of factors all that in as to what type of individual this person is and whether or not they want to approve their petition.
I mean, we only want the rich for
Apparently so. They only want rich workers.
Yeah, that's the whole presentation summed up in 5 seconds. Unfortunately.
Okay, so I also have a question, but I want to make sure I understand. So if someone falls into this box of immigrants that are not subject to the public charge test, but these visas or statuses, eventually the goal is to adjust to being an LPR. Because they started out in the status, and that's how they adjusted to being an LPR, they are still exempt, even though the end goal is.
If they, exactly what you said, if they adjust through that original status. Because someone who is a U or a T visa recipient can adjust their status through that status, but let's say they get married and they want their spouse to petition for them, then that changes. So it really does depend on the facts on like how they're gonna do it.
So can I that reminds me that I should have emphasized even stronger. So once the final rule comes out, there is going to be such a need for the legal aid community to become educated on the final rule, because all of the organizations that serve immigrant families, when they realize that they have a client sitting in front of them who is not exempt, they need to have a really comprehensive, robust resource and referral guide to the legal aid attorneys who are well versed on the new public charge rule, that they can be referred to, because it will be such a fact-specific, case-by-case analysis that we will need to have an army of attorneys to refer people to. It's going to be so fact-specific. And we wouldn't want them to make the wrong decision, like just based on the example that you gave.
Right, because our concern is that I think the agencies providing these benefits, it kind of becomes a conflict of interest of them telling them, no, you shouldn't apply for this benefit because in the long run it might hurt you. And so that's where we come in to educate them. I mean, I have a client who's on a U, we filed her adjustment application. We've spoken twice already. She's like, my friend says this, and I'm like, it's leaked, it's not out there yet. I understand your concern. As soon as it becomes more secure, I will call you and let you know what our plan of action is. But that's the thing, it's like, I am fortunately informed enough to be able to make her feel better, right? But she's called me twice already, right? Like a couple, like when this first got leaked out, and then she's like, again, another friend. I was like, yep, I get that. Keep calling me. I'm like, I will happily keep talking to you if this is gonna make you feel better. Any other questions?
I remember the 1996 when the new affidavit of support came out, the I-864, there was some concern or speculation whether or not there was actually going to be any enforcement of that, and it turned out that there never really was any enforcement, except sometimes in the family law situation you would see the beneficiary against the person who signed the affidavit of support. But there is still that language in there. Was there anything in this leaked document about enforcement of those affidavits of support? Of the government taking any action?
So my biggest takeaway, and I'm not an immigration attorney, was that they demoted the sponsored affidavit in support in weight. They demoted it in weight to the point where it's one of all of these factors. And so that was my biggest takeaway. And just, this test is still a totality of the circumstances, like Rosie said. It's highly subjective, and so what it has done is just made a narrow test and blown it open. But the immigration official has so many more factors now in order that they're required to assess and then make their determination. And when you look back at the slide, I think it was called mandatory factors under the totality of the circumstances test, at least in the leaked draft. The Trump administration basically is telling the immigration official how they want, like what lenses to put on to view each characteristic. So age, all of a sudden. Age now, are you working age? Because the goal of the Trump administration is to help all of the immigrants become self-sufficient. So we're looking through it through, will this immigrant becomes self-sufficient. So age is now, are you of working age? If you're over, I think 65, it's a negative factor. Under education and skills, how is your English? Are you of limited English proficiency? If you're not, it's considered a negative factor. So it's requiring the immigration official to put on a certain type of lens in viewing all of these characteristics to make their determination whether someone's a public charge. Medical condition, you're allowed to have one as long as you're on health insurance that is not subsidized by the government. And then assets and resources here are listed as 125%, but then later on in the leaked draft, it's considered a very positive factor if it's over 250. Any comments? We'll take comments or questions.
Although I'm sure many of us will be signing up to get alerts through your new website, would the CBA be sending something out, you think, or the CBF, excuse me, when there is proposed rules that everyone's aware of it?
Yeah, I think probably, given that we've given a presentation, at this point, once there's proposed rules, it makes sense to alert, when that happens and further training and all that.
So aside from joining and signing up for the weekly newsletter, if your organization would like to join the coalition, we definitely encourage you to do so. We have a steering committee meeting next Wednesday at Legal Aid Society. And then we also have subcommittees, so Andrea and I sit on the outreach committee, there's communications committee, what's the third one? Policy and advocacy. Mikael and I are also members of the legal aid subcommittee, and so there's a lot of committees trying to rally to try to do all this work. And so if you're also interested in that, please let us know.
Thank you. 114, thank you very much.